And your Tuesday could go quickly from Taco Tuesday to Terrible Tuesday when accidents happen on the job. The legal experts at Hollis, Wright and Clay are here to share what to do when that happens. Good morning, Allwin. How are you?
I'm doing well, Stoney. I appreciate you having us on.
A very good topic here. A lot happening in the workplace, accident-wise. So if I'm injured on the job, am I qualified for workers' comp benefits, and how do I get those?
Stoney, the general rule is, and we have so many people, Alabama's such an industrial state, a lot of hard-working laborers out there. The general rule is if you are injured on the job, meaning if you are injured in the line, scope, and course of your employment, doing something in furtherance of your job duties or activities, you're going to have a compensable claim, and you would be entitled to workers' compensation benefits. Something a lot of people don't understand is that it's a no-fault system. We have a lot of people that are engaged in heavy lifting, climbing. They may just fall off a roof. They may hurt their back or their shoulder, lifting heavy objects. And it's nobody's fault. It just happens. But if it happens in furtherance of your employer's, job duties and related activities, you're going to be entitled to benefits. But one thing you need to know is, and it's so important, there is a general rule that the injured employer should report this within 5 days of the accident.
Okay.
Got a lot of people that don't want to cause any harm to their employer, don't want to make an insurance claim, so they try to sleep it off or write it off for a few days, and next thing you know, they didn't timely file that claim, and it complicates the process.
So 5 days.
5 days is the general rule, with exception.
What benefits are injured employees entitled to?
The benefits, it's somewhat unfortunate. The Workers' Compensation Act does provide some benefits, but these numbers were created in 1987. The legislature really needs to work on changing and increasing these numbers. But if you're injured on the job and it's a compensable claim, you're entitled to medical for life for that injury. Some of the rules maybe it's a bad side to it, maybe it's not. The insurance company gets to select who the doctors are. Those doctors decide what the medical necessary treatment is, and you've got to go to those physicians. So you're entitled to medical benefits for life as long as it's medically necessary, and you go to the insurance chosen physicians with some exceptions. You also are entitled to what's referred to as temporary total disability benefits. Some people have surgeries, they come out of work, and during that healing time, they're entitled to temporary total disability benefits, which is 2/3 of your average weekly wage. Don't know why it's that number, but that's the number. It's hard for people to live off that. And something people need to understand during this healing process, an employee may be sent back on light duty. If the employer accommodates that light duty, go to work, go to your job, because if you don't, they can terminate you and you're not going to get that temporary total disability check.
Wow.
Then at the end of the day, once you're healed, you're at maximum medical improvement. You're entitled to what would be referred to as permanent partial disability benefits, and hopefully you aren't hurt this bad, but they're permanent total disability benefits for life as well.
And Allwin, say we're at work, we're injured there at work, but it was at fault of a third party. So it wasn't my employer in a situation where my employer hurt me, or I was injured through the employer as a third party.
That's right, and a quick example is, you have a lot of large construction projects. You have so many different subcontractors on the job, and you may have someone from company A who's operating a backhoe or forklift, and they run over somebody from company B, cause an injury. You not only have a workers' compensation claim, you also have a negligence claim against that third party. And it's important to know this because it increases your benefits, or you can maximize your recovery. You don't deal with the caps that you deal with in the workers' compensation industry that are set by statute. You get a jury trial, you get mental anguish, pain and suffering, future lost wages, and some of these injuries we deal with are catastrophic and life-changing, and you really need that opportunity to maximize your recovery. And at the end of the day, the best thing to do is to reach out and call an attorney. We give free advice, free consultations, and believe me, the employers, these third parties, they have insurance companies that are reaching out to their lawyers to get advice.
What if the employee is at some fault in the situation? Say they didn't wear the proper boots or the proper gear.
There are some, for workers' compensation purposes, if you violate a written safety rule, which is very rare, you have to do it with the intent to injure yourself. It's not really going to apply that often.
Okay.
However, if in a third-party context, it can be considered contributory negligence, which can be a defense to your claim. Alabama is a contributory negligence state, meaning if a jury finds you 1% at fault, then you could be denied compensation.
Allwin, where can we reach you if we're injured at work?
You reach us at Hollis, Wright and Clay here in Birmingham. We handle cases all over the state of Alabama and beyond the state of Alabama. So just look us up. We have a website. We do TV advertisements such as this, and we're easy to find.
Allwin Horn, attorney. Again, holliswrights.com is the website. Thank you, sir. Great
Thanks, Tony.
information.
Appreciate it.
that.
Take
We learned
care.
a lot this morning.